maybe I'll do that in a moment.
Quiet, revealed in Satan.
Now, the charges that I'm going to read to you will not be sent back to the jury room, so it's important that you listen carefully to the instructions. If you have any questions during your deliberation, I can bring you back out and explain the law to you again if you have specific questions about the law. Now, you and I have specific duties to perform, like we discussed from the outset. As the trial judge, it is my responsibility to preside over the trial. It's your responsibility to consider the testimony which has been presented from the witness stand and the exhibits introduced. I have the duty to charge the law applicable in this case. As presiding judge, I am the sole judge of the law, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I tell you, the law is, you must abandon your idea because you are sworn to accept the law and apply the law exactly as I stated to you. Your duty is to determine the facts. In every case, the jury is the sole and exclusive judge of the facts. A trial judge cannot suggest, state, comment on, or make any statement to a trial jury about the facts in the case. Since you are the sole judge of the facts, you are not to infer from what I have said during the progress of this trial and ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you, that I have any opinion about the facts in the case. The law does not allow me to have an opinion about the facts. This is a matter solely for you to determine. As jurors, it is your duty to determine the effect, value, and weight of the evidence presented during the trial. The indictment charges the defendant with murder. The fact that the defendant was arrested, charged, and indicted is not evidence and cannot be considered by you as evidence of guilt, nor does it create any presumption or inference of guilt at all. This indictment is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court and gives this court jurisdiction. The defendant has pled not guilty to the indictment, and that plea puts the burden on the state to prove the defendant guilty beyond reasonable doubt. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is a guiding rule of law that the defendant in a criminal trial, no matter how serious the charge, is always presumed innocent of the crime for which the indictment was issued unless guilt is proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on the evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory. It is not just a legal phrase. It is a real and substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. What is reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. The state has the burden of establishing every fact necessary to prove the defendant guilty beyond a reasonable doubt. The law presumes every person charged with a crime to be innocent, and the burden of establishing guilt is placed solely on the state. The defendant is not required to prove his innocence. Some of you may have served as jurors in civil cases where you were told it's only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. Other civil cases use the clear and convincing standard. In those cases, it's necessary to prove that a fact is highly probable. But this is a criminal case, and the state's proof must be more powerful than those burdens of proof. In criminal cases, the state's proof must be beyond a reasonable doubt. Proof beyond reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. The defendant is not required to prove his innocence. If, on the other hand, you think there's a real possibility the defendant is not guilty, you must give the defendant the benefit of every reasonable doubt and find him not guilty. Necessarily, during your deliberations, you must determine the credibility of witnesses who have testified. Credibility simply means believability. It is your duty as jurors to analyze and evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in the case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of the witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motive in the case. You may also consider the appearance and manner of a witness while on the witness stand. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use the evidence of the earlier contradictory statements to determine the truth of those statements. It's up to you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the weight you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances existing at that time. There is no way to prove intent to a mathematical certainty. There is no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances showed to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state of conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances existing at that time. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty, or to consequences that are considered by the law to be the equivalent of criminal intent. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of the fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond reasonable doubt. This burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. As I mentioned to you during the trial, the rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witness. A witness who, by education and experience, has become an expert in some art, science, profession, or calling, and may state an opinion as to relevant and material matters in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradictory. I instruct and emphasize to you that the fact that the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or the innocence of the defendant. It must not be considered by you in any manner whatsoever. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove his innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt as to the charge against the defendant. The defendant is charged with one count of murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exist for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the evil intent and the act. Malice aforethought may be expressed or inferred. These terms, express and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when a person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other act of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proven beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would simply be an evidentiary fact to be considered by you along with the other evidence in the case, and you may give it the weight you decide it should receive. The defendant has asserted defense of others as a defense to his prosecution. Under the law of self-defense, the defendant may take another's life in defense of others. The right to intervene to protect another person is subject to the same rights and limitations as the right of self-defense. The defendant may take the life of a person who assaults a friend, relative, or bystander if that friend, relative, or bystander would have had the right of self-defense. Defense of others is a complete defense, and if it is established, you must find the defendant not guilty. The state has the burden of disproving defense of others by proof beyond a reasonable doubt, and the burden is carried by disproving any one of the four elements by proof beyond a reasonable doubt. If you have a reasonable doubt of the defendant's guilt after considering all of the evidence, including the evidence in defense of others, then you must find the defendant not guilty. On the other hand, if you have no reasonable doubt of the defendant's guilt after considering all the evidence, including the evidence in defense of others, then you must find the defendant guilty. The following elements are required to establish self-defense, and in this case, defense of others. First, to show that the person being defended had the right to self-defense, it must first be shown that the person being defended and the defendant were both without fault in bringing on the difficulty. If the conduct of the person defended or the defendant was the type which was reasonably calculated to and did provoke a deadly assault, the person would be at fault in bringing on the difficulty and would not have the right of self-defense. Therefore, the defendant would not have the right to use deadly force in defending that person. One's right to self-defense or defense of others is restored after a withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act. Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. Second, the defense of another person is excusable if the defendant had reasonable grounds to believe and in good faith did believe that the person being defended was in imminent danger of death or serious bodily harm from the victim. In deciding whether the person defended actually was or that the defendant actually believed the person was in imminent danger of death or serious bodily injury, you should consider all the facts and circumstances surrounding the crime, including the physical conditions and characteristics of the parties. The defendant does not have to show that the person defended was actually in danger. It is enough if the defendant believed the person was in imminent danger. The defendant has the right to act on appearances even though the defendant's beliefs may have been mistaken. The third element of self-defense requires the defendant to show that under the circumstances as they appeared to the defendant believed the person defended was in danger and that a reasonably prudent person of ordinary firmness and courage would have had the same belief under the same circumstances. It is for you, the jury, to decide whether the defendant's fear of immediate danger or of death or serious bodily injury to the person defended was reasonable and would have been felt by an ordinary person in the same situation. The defendant does not have to wait until the victim inflicts harm on the person defended. The defendant has the right to act under the law of self-defense of others, to prevent the victim from inflicting harm on the person defended. The final element necessary in order to be entitled to defend another requires that the person defended have had no other probable way to avoid the danger of death or serious bodily injury than to act as the person defended did in this particular instance. When the person being defended had no duty to retreat, the defendant likewise would have no duty to retreat. The defendant had no duty to retreat if by doing so the danger to the person defended of being killed or suffering serious bodily injury would increase. When considering defense of others, the relative sizes, ages, and weights of the parties may be considered in deciding the apparent or actual need for force in defense of others and the amount of force needed. A person cannot be required to make an exact calculation as to the degree or amount of force which may be needed to avoid death or serious bodily harm. Therefore, in defense of others, the defendant has the right to use the force needed to avoid death or serious bodily harm to the person defended. The force used in defense of others does not have to be limited to the degree or amount of force used by the victim. The defendant has the right to use so much force as appeared to be necessary for complete protection of the person defended, and which a person of ordinary reason and firmness would have believed to be needed to prevent death or serious bodily harm to the person defended. Where a person inflicts an injury or death on another person, you must be convinced beyond reasonable doubt that the defendant's actions were the proximate cause of the victim's injuries or death. The proximate cause is the direct cause. It is that immediate cause. It is the efficient cause. It is that cause without which the injury to the victim would not have resulted. There must be a chain of causation from the defendant's actions until the time of the victim's injuries or death. Proximate cause does not necessarily mean that it occurred immediately prior to the injury or death. There may be more than one proximate cause. The acts of two or more persons may combine together to be a proximate cause of the injury or death of a person. The defendant's act may be regarded as the proximate cause if it is a contributing cause of the injury or death of the victim. The fact that other causes also contribute to the injury or death of the victim does not relieve the defendant from responsibility. The defendant's act need not be the sole cause of the injury or death, but must be a proximate cause contributing to the injury or death of the victim. Negligence on the part of someone else would not relieve the defendant from criminal responsibility if the actions of the defendant were the proximate cause of the victim's injury or death. Ladies and gentlemen, I have declared the law to you through these instructions to help guide you to a verdict. Whether some of these instructions apply depends on what you find to be the facts. The fact that I have instructed you on various subjects in this case should not be taken as indicating an opinion of this court as to what you should find to be the facts or as to what your verdict should be. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree. Your verdict must be unanimous. All 12 of you must agree on the verdict. The verdict cannot be based on sympathy, passion, prejudice, emotion, or any other consideration not in evidence in the case. Disagreements may arise during deliberations and your debates may become spirited. I urge you to be courteous to one another and respectful of your fellow jurors' perspective as you work toward a verdict. Remember, at all times, you are not partisans favoring one party over another. We're the judges of the facts. Your sole interest is to determine whether the state has proved the defendant's guilt to the charges beyond a reasonable doubt from the evidence presented to you in this case. Again, ladies and gentlemen, your verdict must be unanimous. Madam Forelady, when the jury agrees on the verdict, you will fill out the verdict form, which I have here. It is very self-explanatory. It will go back with the evidence. After you reach the verdict, Madam Forelady will fill out the verdict form and sign. Then knock on the jury room door and inform the bailiff you have reached the verdict. At that time, we'll receive you back in the courtroom. I'm going to ask you to return to the jury room and not begin deliberations until you're told by the clerk or the bailiff to do so. There are a few more matters of law that I need to discuss with the lawyer before you begin your deliberation. All right, so I'm going to ask you to help back. I believe your lunch is already here. So y'all can get started with that. We'll be with you very shortly. I'm going to ask the alternates to please stay with us.
None, Your Honor.
Any exception from the defendant?
Your Honor.
Judge, can you indulge us for a moment? All right. Give me a minute.
All right, while y'all are working on that, our alternates, you are now excused. You do have lunch back there. But thank you for being here. Again, like I said from the outset, we can't do our job without folks being willing to show up. This is very, as you can see, this is a very important job. So again, thank you for being here. But you are excused. And I always tell jurors you certainly have the right to discuss your observations with the lawyer. Sometimes the lawyers would like to see input, but you do not have to. If anyone contacts you in any way about this case and you feel uncomfortable about it, you call back in through the clerk's office and I will take care of it. But you're free to discuss the case with anyone at this point that you see fit. Again, you certainly have the right not to discuss it with anyone. Again, thank you for being here, and maybe we'll show you that.
Well, I think first, maybe we start to go through the exhibits to expedite matters first. Making sure.
Quiet, please.
I would like to just go ahead and, as to the elements of self-defense, I believe Your Honor charged. Okay. With respect to the self-defense charge, said that it was up to the defendant to show these various elements of self-defense. And of course, you also said it was the burden of proof on the state to disprove those elements, or any one of them. And would like to put on the record, I think that may be burden shifting as to this defendant being required to show, and sort of contradicts the defendant to rely on the state's failure to prove those elements. So I just want to go ahead and put that on the record that I think that may be error, and that would be our position.
Well, I guess my question to you, how would the state prove something that the defendant never showed?
Well,
I don't know how else to describe it. I mean, I understand what you're saying.
yeah, it just troubles me because, I mean, I tried a lot of self-defense cases, but I just don't remember the charge being exactly like that.
I have not changed it in the 4 years I've been on this. Not saying I'm right, I'm perfect, and that's what has been in the standard charge.
And I understand. I just want to, if down the road the court decides that that is burden shifting, I just want it to be on the record.
You are on the record, and that is certainly possible.
That's the extent of the argument.
Okay, otherwise, no other exception?
No.
Only subject to our original request, Your Honor.
Yep. All right, are the exhibits ready?
Not yet, Your Honor, we're just going back and making sure there's a clean copy of the state's 7 goes back. There was, I'm sorry, defense 7. There was Carter and the defendant, Mr. Chow. We just want to make sure that's the clean copy, the proper copy goes back. And we're just going through the count right now, Your Honor. So we'll move quickly.
Can I write a couple things down?
All right, don't slow down.